afternoon, everyone. My name is Matthew White, and this is Legally Speaking. We have a really important and really very well curated program here for you today. And as you can see, really very important guest speaker. I'll begin by introducing her. The former Director of Public Prosecutions, Paula Llewellyn, is the first woman to be appointed to the office of the Director of Public Prosecutions within the island. On graduating from St. Hugh's High School, Ms. Llewellyn embarked on the study of law and completed this program in 1984. In that same year, she was appointed in the position of Clerk of Court in the St. James Resident Magistrates Court. From there, she was promoted to Crown Counsel at the Office of the Director of Public Prosecutions, and within 7 years of working in that office, Ms. Llewellyn was appointed Deputy Director of Public Prosecutions. In 1999, Ms. Llewellyn became the first woman to act in the position of Director, and in 2003, became the first female to be appointed in the position of Senior Deputy Director of Public Prosecutions. In May 2008, Ms. Llewellyn was appointed as Her Majesty's Queen Counsel with the Order of Distinction conferred with the rank of Commander in August of that same year. In November, the Director was a recipient of the Civil Service Long Service Medal for 25 years in the public service. Ms. Llewellyn has one daughter and attends St. Mary's Anglican Church. She's also a member of the Trailblazers Toastmasters Club and believes that professionalism and excellence must be at the heart of service to her fellow citizens. Ladies and gentlemen, Ms. Paula Llewellyn. Ms. Llewellyn, how do you feel being here with us?
Well, I feel quite energized. I'm surrounded by young people. I was a guest speaker at the Justice of the Peace Commission this morning downtown, and you had a mix of ages there, but as I look around here, it's just young people. Every single one of you could be my granddaughter or grandson. I'm joking. Granddaughter or grandson.
Young people at heart.
Yes.
Everyone
yes.
here. All right, to our first question. So, tell me, what inspired you in the first place to pursue a career in criminal law and eventually become the DPP?
Well, when I was at primary school, St. George's Primary, I was quite shy. And I used to think I was quite an ugly person, not an ugly duckling. Because if you're an ugly duckling, you're expecting to become a swan. But if I were to say that I had any beauty, I was a real nerd. It was the fact that I loved to read, and I couldn't be matched when it came to vocabulary. But I was a little bit on the shy side. I spoke with a lisp, and it was not until I went to high school, St. Hugh's High School, for girls, that I realized that I was not only, really enamored by reading and vocabulary, but that I was also a frustrated actress. And I loved drama. So for me, the study of law signified being able to marry my two loves, which was drama, melodrama, and being a frustrated actress, and my love of words and English language and literature, and just being able to articulate, to enunciate, and to, read. In fact, when I just went to high school, my ambition was to become a librarian. You know why? Because I was such a voracious reader and a speed reader that I couldn't keep up with the number of books that it needed to, assuage my hunger. My poor mother, she couldn't keep up, I had encyclopedias. You all would know about encyclopedias. You've heard of it. And I used to just pick them up and read about any and everything. But Nancy Drew, my mother would say, go and use the mop and sweep out the front of the house. And I'd say, Mommy, I'm going to the bathroom, and I retreated to the bathroom with 3 books. And by the time I come out of that bathroom, my poor thighs are burning because I've been sitting down for too long, but I would have read the 3 books. So I thought that loving reading the way that I did, my purpose and ambition in life had to be in some sort of library where I would have all these books. Can you imagine? Mm-hmm. But by second form, I realized, no. You know, I really am a bit of my father's child after all. I look like my mother, but my father is very flamboyant. He was the quintessential village lawyer and very, very flamboyant. And the rest is history. So by third form, I knew that I wanted to do law. And by that time, no, I was no longer shy. You know, I would break into Shakespeare, you know, out damn spot. And I'm just talking normally to my friends. You know, but I really, really love literature and language. History too, and in fact, in the general paper for GCE, I got an A. You know, language I did from 4th form, literature, I just love reading and the words. And even now, I lament that although the present generation of young people, all of you, you are so technologically savvy, you are so good with the technology. And I have a daughter, she did 2 degrees at Purdue. One is in cybersecurity and one is in law and society, English and Spanish at the same time. But although, you know, I lament that, call me an old school, but that ability to appreciate words, the nuances, the vocal variety as it rolls over your tongue, to enunciate the diction, to articulate that it is no longer something that is revered by our young people. And in a way, the fact that everything is at the press of a button has caused not only a lot of instant gratification with a lot of our young people, but a lack of patience. When you really are a reader, it teaches you patience and critical analysis. Mm-hmm. And the last 2, there are some of our young people who don't recognize that one can go even further than being superficial or shallow. So you may be very good with the technology, but lack, I find, a lot of young people emotional intelligence and being able to read up people, empathize, sympathize, have emotional intelligence so that you can read people and know how to operate. What we have is a cut and dry. I want this by this time, I want that. And sometimes when you check it out, the critical analysis is missing. But yet, they are very, very good with the technology. So what I did with my daughter, I was determined that she will tell you she was not going to be a zombie. So from she was a baby, I would read to her everything. From she was about 2+, I taught her how to go into a bookstore and to browse, the concept of browsing. And I taught her that if you want a book, I'll buy 1 book for you. I also put the subtitles. This is how valuable reading is to me. I put the subtitles on the television to crawl, so that as she was growing up and she would be watching a cartoon, she's also accustomed to seeing the words go by. And I also taught her the whole issue of why it is important to be courteous, so that she, although she was able to read very well and fast, she could not go on a channel that was not prescribed by me without my permission. And another thing too, though after she was 4 or 5, she's 27 now, and several of her friends had the DS, and which was 6, 7, 8, the BSB, and that was it in those days. I told my friends and her father that I did not want her to have any of these games. Every year when she had a birthday and we would keep her birthday, she would get books. Right? She would get books, but guess what? She would come home from prep school and tell me that an encounter with another child, and then she would tell me that, but mommy, he's like a zombie. All he does is go, what you say? He doesn't know how to have a conversation. So with that, she became confident. So if we went to a hotel, she's 6 or 7, she would be the first person to say to the waiter, "Excuse me, sir, do you have a kids club here?" You know. So and one of her dreams, which she confessed to me several years ago, was to be able to read as fast as me. In fact, my staff at the office of the DPP would say behind my back, "Do not read anything on the computer or anything with Miss Llewellyn, because she's going to gallop ahead of you and wait and be doing other things until you finish that page or that page." But it was because I had been a voracious reader growing up. So I did a bit of speed reading. And I had her, when she was at Immaculate, do a course on speed reading. So I said to her, there's no way any child of mine is going to be a zombie. And now, guess what? She is very good at technology, so much so that she did a Bachelor of Science in Cybersecurity at Purdue University. But she started out doing Law and Society, English and Spanish. And they gave her permission midway to start the other degree. She got 6 exemptions, which she argued for herself. And at the end of the day, she had her 2 degrees on the same day. You know. And also, what happens, I think, to a lot of young people of today, I don't know if it's because you all get so much so quickly and everything is made easy. No, but I find that young people of today, together with the fact that we're in this arena of instant gratification and entitlement, I find young people of today tend to be a little on the fragile side. Am I wrong? Tend to be on the fragile side. And because a lot of people are preoccupied with the gilded lily image of what you see on social media, you find that something like character and mental toughness and being able to really push back when challenges are upon you, or being able to, as TDJ says, be anointed by the challenges. You find a lot of young people of today find it hard when the going gets hard, and that is very unfortunate. So you are very good at the technology, but the sacrifice has been that although it may appear to be very old days, I don't know if any of you read Dickens, and I have to ask, in my day it was accepted that you couldn't go through high school without having had a taste of the old masters. Shakespeare or Dickens or Jane Austen or any of those books. If you notice in those times when you didn't have any television, any radio, if you notice language and the ability to speak, the nuance, the double entendre, it was the thing in those days, unless you are in a particular circle of friends who have and share that interest. The art of conversation and the use of words over and above the superficial, then sometimes some persons are just stuck with their greatest companion being their computer, which is unfortunate. Because do you realize that you are now in an era, you will see so-called lovers or girlfriend and boyfriend or husband and wife going out to dinner, and they're at dinner and the both of them are on their phone. It's very unfortunate. So the art of conversation, if one is not careful, I wouldn't say it's dying, but it's not as revered as it once was. And you tend to find, just listen to some of your friends, no matter how bright they are. Even take, for example, on social media, my daughter used to laugh after me because I don't do the short form. Instead of Y-O-U, you put U. I don't do it when I'm texting. And she would laugh after me. But guess what? She doesn't do it either. Certainly not when she's texting me. And I was speaking at a Bankers Association conference and sitting at the table with one of the vice presidents. And the lady said to me, Miss Llewellyn, can you imagine? We're talking about the same thing. That a young lady, degreed, accomplished, according to her CV, came and interviewed for a job at the bank. And would you believe that in the way that she was speaking to us during the interview, she was speaking in text, short form. And she laughed and she said, oh my goodness, I'm so sorry. So in other words, she's just talking in the interview and would say something like LOL. You know? And several short forms that you would use in terms of texting. Needless to say, although the young lady had the degree and had a fairly good CV, she did not get the job. Because what they would want is somebody who would demonstrate that they are aware of their arena, right? And that you are able to multitask. So you are good at technology, but you also have some measure of emotional intelligence, and you are able to converse. All right. So that is what led me to law. Just the fact that I was call it a frustrated actress who loved drama and also loved words.
We're just going to transition to this microphone. See how smooth it sounds? I think a lot of us share that. That being, well, I always was born for the stage. And I'm going to get there. A lot of us share that. But I hear in your answer some really complex balances, you know, an appreciation for humanity and how to interact with people, but then also an appreciation within yourself that the world isn't always kind and catered to you.
Not at all.
And that you have to be able to resist that. And the love of freedom is really important, but there must have been something else that pushed you to have that firm sort of state of mind. Can you point to anything in your career as a prosecutor, or maybe in your high school days when you went to university, that best shaped you to become the DPP that you were?
Well, it was the mentoring of my parents. My mother was a nurse. She could be hoity-toity. She could be down to earth. My father was a raw-jaw countryman who believed that the work ethic was the greatest thing, better than sliced bread. Both of them were very strong mentally. Both of them were extremely hardworking. Both of them believed that nobody was better than them. And both of them strongly believed in education. My father had been a farm worker. He never completed or had tertiary education, but he was very streetwise and he was extremely confident. I remember after he died at 99, about 3 or 4 years ago, I retrieved his constitution. And when I looked in it, at section 94, which is the enabling provision to the DPP, my father had put in red ink, my daughter Paula Llewellyn is now the DPP. It almost moved me to tears. So here was this farm worker who believed that nobody was better than him, and his daughter was now the DPP. So real elementary for my parents, how we were brought up. There is no way my sister and I could be in bed on a Saturday morning with the sun up. No way. According to my daughter, she would never live in those times. No way. So we had to come down. He would call out our names to come and help him with the lawn, or to come and help him cook. If my mother was going to school and we got sick, running a temperature, you know what my mother would do? Dose you up and send you to school. So it's the teacher who would have to say, oh, you had a mother like that? Yes. The teacher would say, you have to come for your daughter because she's roasting with a temperature. When I was doing O-levels, I was doing 8 O-levels, and several of the girls, they were able to stay home, said they're studying. I had to go to school every day up to the day of the exam. So quitting or not giving of your best was not a part of my parents in how they decided to bring up their children. And my mother used to say when she goes to bed at night, she doesn't say, oh, Paula, who art in heaven. She said, oh, Father. And she will not be a delinquent parent. So we just knew that. And in the same way, I realized that I have grown my daughter the very same way. So the day that she set foot on Purdue's campus, I said to her, Leah, you have to get a little job somewhere, the work ethic. And she said, Papa, I said, you have to get a little job somewhere. So she used to do this thing where you would call the alumni of the university to tell them about what is happening and ask them for contribution on behalf of the university. And I used to call it her minimum wage job. Right? But guess what? She stuck to it for a little bit until she found a job at a restaurant, top restaurant in the area, on the weekend. So remember, she's carrying a heavy course load, but to get her pocket money, because she knew her mother was just a public servant who didn't earn much at that time, but at any time. And she got it, and she, of course, everywhere she goes, she's either the only black person, or, for example, she was a tennis champion at Immaculate. She got a scholarship to a boarding school, which was quite wealthy, and she was the only black person on the tennis team, but she powered them to the championships in terms of the finals. And everybody remarked, first of all, how come she played tennis so well? How come she doesn't even play basketball? And how come she was so confident? You know, but for those of you, whenever you do become parents, it is very important for you to be purposeful in terms of the environment, mentally, intellectually, spiritually, and everything that you set for your children. Because I was very proud of her that she really took on the second degree, and it was difficult. Purdue is known for the sciences, and you have to get permission, and you have to have a certain grade average. So she was carrying 7 courses at one stage, 21 credits, and she just powered through, although it nearly killed the 2 of us. Because she said her friends would ask her, how come your mother talk so regularly? And she would say, my mother is my mental health professional. And guess what? She's as melodramatic as I am, you know? So, I think certainly how my parents brought me up, that is the primary Listen, when we had Gilbert, we lost our roof. A lot of people lost their roof in Kingston. It was devastating. At that time, I had been working at the office for about 5 years. I drove a ladder. And I'll never forget, we had another house in Pembroke. And Daddy said to me the morning after, come, we're going on the road. And I said, but Daddy, look at everything strewn on the road. How are we going to get through? Come, you're going to drive. So there was no word such as can't with my parents. And the work ethic you had to keep doing. And that is how we were brought up. Not to mention, as my mother used to say, when people ask me how come I'm not intimidated, I say intimidated with my father. My father would say, what's wrong with your sister? You know, so it just don't occur to either my sister or I to be afraid, you know. And I've said to him, if nothing else, he did give us that in his DNA, that ability to be courageous. And I thank them for it. So that was really what happened. And then I had my mentor, Marva McIntosh, former senior police judge, when I became a prosecutor at the office of the DPP. And she guided me as well. And in her own quiet way. I was raw material. I was like putty or like clay. And she guided me. And, you know, encouraged me that no matter how challenging the experience was or the case was, you know, go into it with gusto, but prepare. Because it's when you go into these challenging matters that you will learn a lot. So when I reflect on my career, and I was known for it, over the last 40 years, there is no King's Counsel or Queen's Counsel, including PJ Patterson, who I have appeared against and done well. You know, and after, you know, I keep saying they have to teach me as well. Yes, they have to teach me as well. So that is it. But life really is about how you decide to engage it. If you're going to look at the glass half empty, then you're going to start with a deficit. So you have to be able to, and I speak about this in motivational speeches all the time, self-actualize or self-motivate. You have to have fixity of purpose. You have to be competent at what you do. If you're not competent, you have to be able to have that man in the mirror moment. Face your flaws and see how you can get over it. You have to maintain a sense of humor as well. You have to remember that the underbelly of success is humility. You have to have good self-discipline. You have to have the ability, like a master batsman. How many of you here know about cricket? Alright? Think of a number 3 batsman who is supposed to be the best man on the side. You have to be able to know, pick up the line of the delivery, know which ball to play, whether for a 4 or 6, or which ball to leave alone. And that's what life is about.
I think it was Miss McIntosh you mentioned said that there were 2 things that cannot be taken back once released. 3, the flung arrow, the spoken word was the 3rd one.
Opportunities lost.
Opportunities lost. But let's move to melodrama of a different kind, the legal system. As former DPP, I'm sure you're happy to be in a freer position to talk about our criminal justice system. Very proud, I'm going to give you a long rope. What do you think the biggest challenge we have in Jamaica with our criminal justice system?
I think the lack of resources. When I took over as DPP, we were really in very straitened circumstances. You had like about 23 lawyers, everybody was burnt out. We had started to see crime, the
product of the increase of crime in the number of cases. Listen, there was a time all the prosecutors would tell me that you would go to a parish like Hanover, and I think they had a thing where when they have the parade with the judge, they would show the white flag. Not white flag, white gloves, meaning that no cases had been committed for the circuit. So they basically opened it on the day with the pomp and ceremony and closed it because there was no committal of any case to be tried in the circuit court. Same thing in Trelawney. But with the tripling of crime, you know, we have had a lot of cases coming into the system. And what has happened is that the resources, both human resource, whether the judiciary, prosecutors especially, and also the resources in terms of providing for the expansion of the population in terms of how you modify or build courthouses coming from the colonial times has not kept pace with the demands of the public. So I would say it's a lack of the resources because people in the system at every level, we have always had good ideas, but it's just that somehow, even when you get some resources, for example, I would say I tripled the number of prosecutors, and we are perhaps maybe the biggest or next to the biggest in the Caribbean. So when I took over, we had about 23 prosecutors in DPP's office. When I left, you had 70 legal spaces on the establishment. So I had to take it up gradually, 40, then 50, 58, and then 70. And it's a very involved process between the Ministry of Justice and the Ministry of Finance. You literally have to craft justifications with data, statistics, because you have to show the Ministry of Finance that it is worthwhile. And very often there's a disconnect, and I would say, between the Ministry of Finance and their close understanding of some of what ails the justice system. Right? So I would say it's a lack of resources. And right now, where the circuits are, Westmoreland Circuit, I remember we have the assize period. So every term, you have the Hillary term, which is from January to early April. You have the Easter term from the end of April to the end of July. Then you have the legal vacation in August, and then you have the Michaelmas term from the middle September to maybe the second week or third week in December. So what is happening now? Each circuit, each parish is to have a circuit, all except Kingston, which goes right throughout the year. And all the circuits are overburdened. No. In Westmoreland, we used, well, I think they're still doing it, send 3 prosecutors because you're talking about 300 cases in a circuit. And that is why prosecutors, once you pass through the office, you become, dare I say, battle hardened. I mean, we have fun, but you are able, that is what the training at the office does. And I say with the greatest respect to the defense counsel, which is why when you see us at the law school, if you talk to an average prosecutor, you're dealing with indictments and so on, you can just turn and you just start to draft. Because you are drafting indictments in so many cases. So you have to know the nuts and bolts of it so your indictment stands up. So after a while, you get to know quite a few of the sections by heart. From when you're a clerk of court, and then of course when you are a crown counsel. So the resources have not really kept pace with the population expansion, the complexity of so many things that we have to deal with. The police had a problem in that they were undermanned. I think they are up to full complement now. But it took a concentrated effort over the last, I would say, 5 years, and opening up other facilities to train, to get them up to the 14,000, I think, which was on their establishment. And I suspect, as I speak, the High Command is trying to do the justification to get more bad boots on the ground. Because crime has just tripled or quadrupled from pre-colonial Jamaica. So in the same way now, we should be having a situation where the circuits for all the parishes literally sit right throughout the year. But you don't have enough judges to deal with that. And I'm not quite sure you will have enough prosecutors as yet. But I know the Chief Justice is aware, we have spoken about it, and we just have to try to do the best that we can. We still have made a lot of advances, and let me tell you something, ladies and gentlemen. When you go to the Eastern Caribbean, and I've been to most of the islands, Jamaica is way ahead in terms of one, the synergies between prosecutors and police officers when it comes to high public interest matters, right? Two, the fact that we no longer have police prosecuting in the parish court. We have entry-level lawyers coming out of the law school who are able to get jobs and get on a path to a career as a prosecutor from the parish court. In most of the Eastern Caribbean, they don't have that. They have police officers prosecuting in the law court. And that is why sometimes they come to Jamaica, and to get people to work at the DPP's office, they go for clerk of courts. You have to have spent maybe at least 2 years, 2.5 years as a clerk of court. And be pretty good to come to the office of the DPP. We are ahead of them in terms of our use of digital and material, cell-site analysis and all of that. I would say we are ahead. We are certainly far ahead when it comes to anti-gang prosecutions. I was addressing a roundtable of 7 attorney generals from the Eastern Caribbean, including Ghana, Belize, and Barbados. And the Trinidadian Attorney General, he spoke, and he said that they have mounted 35 anti-gang prosecutions. And they, in all of them, guess how many convictions they have gotten? None. So of course, you know, Mr. Jeremy Taylor, when he came to the podium, we tried not to boast. We were just factual in terms of what Jamaica has done. So that huge gang matter that we did, led by Mr. Taylor and the present DPP and 2 other prosecutors, the Klansman, Black and Brian case, where we had a prosecution of 30-odd persons. That has not happened in the Eastern Caribbean. That hasn't happened. Even what is going on now in the court, led by Mr. Yannick Forbes and 2 other assistant directors. He's a deputy, and we're prosecuting Tesha Miller and 20 of his colleagues. That doesn't happen there. And I'm going to tell you, I've seen about 2 or 3 attorneys from that case up to just a little earlier, and they all commend the prosecutors and say they're on the board. So you can imagine how voluminous, I can tell you, it is to prepare those matters. Plus you have the security issues, because each of them have to have a bodyguard as well. Right? And it's over 20-odd, 30-odd counts on the indictment. And we do electronic servicing of the documents. You go into a drive and then you are able to upload. Right? That is how we have to serve in those big cases, electronic service. And you have to be able to preempt all the areas of law and be on the ball with it. So this is why I'm saying, and every single Crown Council, no matter how young you are, unlike some of the countries in the Eastern Caribbean, in many cases only the DPP and her most senior counsel to the Court of Appeal. Same thing in Barbados. But I'm able to tell all in Jamaica, once you set foot in the office, no matter how junior you are, within 6 months to 8 months, you will be going as junior counsel with a senior to the Court of Appeal.
and you participate and know how to prepare the bundle, how to prepare the papers. When you go to the Court of Appeal, it makes you a better advocate at first instance. So all that exposure, plus we are the only office in the Caribbean that has a multiplicity of units: extradition unit, mutual legal assistance unit, anti-gang unit, digital and cybercrimes unit, to name a few. And we have many other units. We are the only one in the Caribbean. And everybody who is in a unit, everybody prosecutes generally and goes to the Court of Appeal. And that is why, don't tell anybody I said that, when you come through the office of the DPP, the people at Services Commission will tell you that 90% of the time, if they are interviewing persons from the defense bar who have never had prosecutorial experience or any other area of the service, say you come from Ministry of Labor or somewhere else, and you are interviewing counsel who has had prosecutorial experience, even if they are in private practice, 90% of the time, the person from the DPP's office will always get the nod, because you're accustomed to shouldering a lot. And the bench court, they hold you as a prosecutor to a much higher standard than when you're a defense counsel. So you have to be on your A game, not some of the time, every time. And you have to have testicular fortitude. Absolutely. One of my favorite phrases now. You have to. Because when you are going up against, let me say, the most amount of lawyers I've been up against is about 14. I was prosecuting 4 accused, and everybody had 1 or 2 or 3 lawyers. I had 1 junior, I was a deputy director. But when I'm in a multiple accused case, it's just great for me to say, when you are introducing to the jury, well, I love to appear before, that you know, so and so accused A is represented by Mr. So and so, Mr. So and so. The trial. So and so, Mr. B is represented by my learned friend, so and so and so and so. So and so, C is represented by their friend, so and so and so. And I get to the 4th one or the 5th one, and then I pause. And it is only I, Paula Llewellyn, who represent the crown, but we're not intimidated in this. And of course, I usually is a smile, and then behind me, you would have several of the lawyers. You want to see, you want to see. But it goes with the territory, and advocacy, if I had my life to live over again, with all the challenges that I've had to face, I would make the decision. As I said to Mr. Patterson, PJ Patterson, after I appeared against him, and Arlene Harrison Henry, the former public defender, she was his junior. So he and his partner, Carl Ratchet, invited me to join the law firm. I said to myself, look at it now, they're primary, commercial, and conveyancing. I certainly would have been earning much more than what I earned as a prosecutor. But guess what? I would not have been happy. Because the passion, money has never been my trigger. Rank has never been my trigger. I have to love what I do and have a passion for it. Because it's when you love what you do and you have the passion for it, that when you get tired, you get demotivated, that is what carries you over the potholes. And you are able to win and come again to do the best that you can in terms of giving service about self. So, resources, that is never ending. To the Chief Justice, they will tell the same thing. If you spoke to the Attorney General, the Solicitor General, they will tell the same thing. But guess what? You have to take lemon and make lemonade. You can't sit down here complain. And I think in Jamaica we do pretty well with what we have to do. And that is why
we are requested on so many occasions to participate in seminars abroad, to give papers, and to share our experiences in terms of how we do things. And they over there read a lot of the cases. I mean, I have been to several, I can't tell you what people and young and practitioners have said to me. Because I thought I was only doing in Jamaica, but alas, you know, my love for drama, it's known everywhere.
Let's switch gears a little more and sort of shorten the loop a little bit. We're going to go into an ideological conversation. We're going to use a little case study to bring it up. I'm going to give you a little brief on what the situation is here. We're going to analyze. The Joel and Silvera case has reignited debate in Jamaica. Yes, that's what we're doing! The Joel and Silvera case has reignited debate in Jamaica about how the law treats killing within intimate relationships. Joel was charged with the murder of his wife, Melissa Atkinson Silvera, but the court ultimately convicted him of manslaughter rather than murder, accepting circumstances consistent with provocation as a partial defense. In Jamaican law, under Section 6 of the OAPA, provocation arises where an accused loses self-control due to things said or done, and the jury must decide whether a reasonable person would have acted similarly. And for reference, the thing said in this instance, as Mr. Silvera reports that he was the only person there, that his wife said some violent, disgusting things about their children. I'm going to continue reading my brief. This defense does not excuse the killing, but reduces the severity of the offense, reflecting our recognition of human frailty. However, its use, particularly in intimate partner violence contexts, remains deeply controversial as it often depends heavily on the accused's narrative of events where the victim is no longer able to respond. This case directly connects to what we are studying, especially criminal law and domestic violence legislation in Jamaica. Provocation acknowledges loss of control. Laws like the Domestic Violence Act are designed to protect victims and recognize patterns of abuse, control, and power imbalance. The tension is clear. Does allowing provocation in these cases determine or undermine the very protections the law aims to provide? Critics argue that it can excuse male violence and shift blame onto victims, while others say it still has a place but needs stricter limits in modern society. So the real question becomes whether the law should continue to recognize provocation in its current form, reform it to better align with contemporary values, or abolish it entirely in cases of intimate partner violence. I think the thing here, this is really heavily packed. But the outrage for many persons came from this high profile, the fact that the judgment was made in a lot of ways, really, of the sole evidence that he gave from a situation only he was presenting. And of course, the matter of gender. Anybody who listened to the hearing, you could have heard the judge's critical analysis of crimes having to do with guns and the necessary increasing of sentencing for that. Ms. Llewellyn, as Director of Public Prosecutions, your personal interest has also been towards striking a balance between public interest, public outrage, ensuring that the exercise of the law is for the people. What do you think of the modern law of provocation? And whatever effects it may have, or whatever sort of tilt it may have in favor of one gender or the other.
Counsel to be, you have tried through the back door to invite me to discuss the Jordan Silvera matter. I'm going to shut that door in your face. I have been called by quite a few people in the media, and I have declined to make any public commentary on it because I think it will be inappropriate and I think it will be disrespectful to the present DPP, my successor, who exercised a judgment based on what she had to deal with on the ground. So I'm not going to discuss that case. But I have had experience with prosecuting cases with intimate partner violence. I mean, the very well known and long completed case of Mary Lynch, I think is known by all of you, where Mary Lynch, a society housewife in Cherry Gardens, who used to be one of the first informal commercial importers. She sold high-end clothing. She was married to one of the vice presidents of NC. He was a Barbadian national, and on a particular day he was supposed to be at a meeting. When she was called, she told the people at the back that he had gone to races in Kentucky, in USA. Now they know him. He was a workaholic. There's no way he would have done that, and they had a high-level meeting in the back. So persons went to the house, and from what they saw there, they realized something was amiss. And then one thing led to another, and she was eventually, after the investigation, arrested and charged for the murder, especially after the remnants of his bones were found several days later. Somewhere by smoking Now, I prosecuted that case. I was up against Frank Phipps, and it was really our O.J. Simpson matter. But it was a classic intimate partner violence, although it was perpetrated by a woman. We found the skull, and on the skull, you had 11 chop wounds. Any of those chop wounds could have killed him. I think he had just sat down on the bed, and then she attacked him, because you were able to see what you call some blood spatter in the ceiling, which the forensic analyst called aerosol effect. Right? As the machete is going up, the blood spatters, and she brings it down again, and she brings it up. Now, at the trial, the defense put us to proof, meaning, you know what the ingredients are for murder. You have to prove the mens rea and the actus reus, right? Cause serious bodily harm, the intent to cause serious bodily harm. You couldn't pick up from the papers what exactly the defense was going to be. So, using my experience as a deputy director then, I realized that there were pretty much to prove. So what I did is had the doctor, the dentist, because we used an impression that he had done to get some work done, and matched it to the mandible. Part of the mandible was found to be able to identify that it was in fact Mary Lynch. And it was not until she gave sworn evidence that she started to talk about the battered woman, in effect syndrome. So there was nothing said through cross-examination about that on the Crown's case. So, battered woman syndrome. And I cross-examined her. If I do say so myself, it's one of the best cross-examinations in my career. And she was very aggressive. And of course, at one stage when I said to her, is it because, she said, I made him. And I said, so you made him? Because she was jealous. She thought that he was carrying on with somebody else. And I said to her, so that means you could break him. And then she literally almost came at me. I don't know how she didn't jump out of the witness box to say that I wouldn't know I've never been married. Right? What's this to make a man? Right? And if she made it, you know, right? And I stepped back theatrically and danced. Because he said he should come out of the box. But when I gasped, I looked around at the foreman and saw that he was quite taken aback as well. I said, good, gotcha. Right? Gotcha. You know, but intimate partner violence is not a new phenomenon in Jamaica, but it has just become much more prevalent because people too often are unable to resolve conflict. Now,
the traditional thing is that in regular circumstances, you take a plea to manslaughter if it arises on the Crown's case. It is in the rare case that maybe because of circumstances on the ground. So you may have a very strong case on paper, but perhaps in terms of the deliverability of the viva voce evidence, you may find that the game was quoted here or there. When I prosecuted the case at Oakland, you might have heard about that wealthy businessman who people thought that he had thrown his girlfriend, who was a beautician, over the balcony, but that's not what he did. I think he killed her in the apartment. I prosecuted that case against Jackie Samuels Brown, and it was a classic case of intimate partner violence. Both of them were no longer with each other, but they haunted each other. And her new boyfriend, was supposed to pick her up. A girlfriend was visiting her. She had just gone there to pick up some more clothes, because this guy would, sit in his car and watch her at her apartment. This guy would call her 20, 30 times. And lo and behold, he told the girlfriend a bad word at about 11:30, and she left. And in fact, when you went to the house, you saw the pictures, her slippers were still outside on the mat. I think as she came back in, he tackled her, and he was much bigger than her. And he admitted that they had a fight, but he said she ran out. Then he found her body downstairs, and then he picked her up, carried her to the hospital, and the police said that he was, because he had been crying. So that was a tough case, because manslaughter was clearly live in terms of what he said had been happening in terms of the fight, because the fight between them, carried the provocation as well. But the judge left, and when I'm telling you, when I say she left it was almost as if she left it, right? Killed the lily, left it. But I always thought that I had a very strong case in terms of murder. And the jury convicted for murder, he got life, 20 years. So he has to serve 20 years before parole. It's a difficult call to make sometimes because of the circumstances. Because you have to balance the evidentiary material as well as the public interest. And there's always going to be a constant tension between the court of public opinion and the court of law. I don't want to say anything about the Sylvia matter. I really would rather not. What I would say to you is invite the present DPP and her junior to a sort of discussion like this, and speak with her in terms of what informed her in terms of why the decision was taken. I believe I know now, having spoken to one of them, why it was taken, but it's not for me to say. All I will say is that sometimes you can have very, very strong cases on paper, because on paper it would be a very strong case for murder. But on the other hand, up to the day, you don't know. I have done cases where what you call footworks about. In other words, the game is quoted. You only hear it says to the police. So where are the exhibits? It is critical. It's a boy understood. There was a flood in the storeroom, and one long story, which is really saying they don't have it. And then you have to draw for your law now in terms of asking the court to find that the evidence, the verbal evidence of the existence of this chattel should be admitted to prove that it really was there. You know, so as for provocation being done away with, no, I would never agree with that. What I think coming from the Chief Justice's judgment, so what he had to say is that I think he thought outside the box and he went for the Trinidadian position, which is shared by Belize and Cayman. And what I would like to see coming out of it is that the legislature, on recommendation from someone, or even hearing what he had to say, or from the also, that Section 6 of the OPA be amended to indicate that where manslaughter is committed with the use of a legal or illegal firearm, then there should be a mandatory minimum of 15 years or 18 years. That is what I think you could all bring into the public domain to discuss. Whether we follow the route of some of these countries in the Caribbean, especially in light of when you look at the policy behind the new firearms legislation, where it's almost a zero tolerance as it relates to being in possession of a prohibited weapon. You know, or if you make use of a firearm, even with the use of a legal firearm to commit a murder or some felony. So I think that is what I would say comes out of that matter, which I think can enhance the administration of justice. But there is a room for manslaughter based on provocation or diminished responsibility. Because guess what? I nearly said, guess what, guys? That's a young part of me, meeting you all halfway. Guess what? You're dealing with human beings. And once you're dealing with human beings, listen, all you hear is talk about AI. It cannot replace that element that a human being has, which is emotion and being able to make a human judgment or to refrain from acting. So once you're going to have the possibility that as a reasonable person you can lose that self-control by words said or acts done, then I believe there's nothing wrong with you having the benefit. But the thing is, partial defense, you have to hope that the evidence, well, as we say, you have to hope you don't meet Paula Llewellyn. Because it always amuses me when I have a case. I offer, in fact, in that case, Stephen calls it matter, I offer the defense manslaughter. Because he freely said to the police, we were having a fight. But he said she ran outside and he found her downstairs. Right? Which was a lie. And I was told, absolutely not. We're not offering a plea. And then the manslaughter, provocation. I said, okay. But the thing with me is if I offer you manslaughter and going down the line now, you realize the going is getting wrong. And you come back to me, I'm not taking it. Because all I want to do is address the jury in my final address. I see the murder conviction staring me in the face. Right? So each case has to be assessed on its own set of facts and circumstances. And what social media has spawned, everybody is now a prosecutor, everybody is defense counsel, everybody is a judge, and everybody is a police investigator. And when you say, did you look at the entire, did you look at the file? No. So I said, oh, you know, what exactly informed the particular prosecutor in making their decision? You know, and which is another reason why I would never make a commentary. I told them would it be inappropriate or disrespectful. But although I was there as DPP when the file came, I was not there when it was to be dealt with. So what I would suggest you do, when the dust settles some more, invite the new DPP to come, and the DPP and the Assistant Director who actually had conduct of the matter, to come and talk with you in respect of what informed their decision to take that course. But I do not agree that we should have a scenario where you do away with manslaughter in terms of provocation, because the human condition will always, whether in Jamaica, Barbados, America, Canada, Russia, you will always have persons who will act in this way. It is for the tribunal of fact, usually if it goes to trial, to decide whether it was murder most foul or manslaughter based on provocation. The legislature to look at section 6, do an amendment so that we can follow what Mr. Justice Sykes used coming from the Trinidadian situation. Because if you look at the judicial sentencing guideline, the range is 3 to 15 years. The starting point is 7 years. You know, and there's just no way, given the severity of the aggravating factors, that the Chief Justice could have gone along with that. And as he said, there are guidelines, but I can tell you, by and large, in the Court of Appeal, they tend to follow them. So, either the judicial sentencing guidelines, which I have said in the past, need to be updated and reviewed, and or Section 6 of the legislature needs to take another look at Section 6, do an amendment to provide that a minimum, perhaps mandatory sentence be given if it's manslaughter by use, provocation by use of an illegal firearm or illegal firearm or illegal firearm. In my experience, most provocation cases in intimate partner violence usually involve this, or a stone, or some implement to hit the deceased, or a knife. Usually, most times. That's what provocation is. Very, very unfortunate. Final question? But I have to give him A for effort. I have to give him A for effort in my class. Right? And I suspect I saw a couple of you looking at the almost closed expression on my face, because you knew that I picked up the line of the delivery, and that was a little ball. Okay? But notwithstanding that, because we're in a teaching environment, I am not a quitter. So I had to find another way to still answer you without being drawn into a discussion of the Silvera matter. But please invite the DPP and the Assistant Director who dealt with the matter to come and address you all on the subject of provocation and on the subject of the case. Now that it has been completed. All right?
I think we'll take you upon both of those.
And now, all revelries have ended. And I'd like to ask Ms. Llewellyn to join me at the front of the stage. This very real stage that we have in front of us.
All the best to you all in your journey of success. Remember, never give up. All right?
Can I take my boat? I'm Matthew White. This has been Legally Speaking.